No will rules can leave you stuck outside your own front door. Do it today. Check how the property is owned so you've got control when a crisis hits. Many unmarried couples believe they're protected, but in England and Wales, the law doesn't give automatic rights over a shared home if one partner dies. That gap can leave families facing confusion and stress, especially when the paperwork isn't ready or roles aren't clear. So let me explain. One couple buys a place, decorate it, pay the bills, build a life that looks settled from the outside. Then something happens, and the surviving partner is suddenly asked for paperwork they've never seen. I've watched people go from grief to panic in a single phone call because the first question is not about feelings, it's about legal authority. What people expect is loyalty. What the law does is follow ownership and documents. In England and Wales, if someone dies without a will, the starting point is the no will rules, intestacy rules. Those rules set out who inherits, and they do it by family relationship, not by how long you've lived together. And a married partner is not treated like a spouse, even if you shared a home and shared costs. That doesn't mean the surviving partner gets nothing in every situation, but it does mean you can't assume the home passes to you automatically. If you died this weekend, who could actually act for the household and who would have to ask for permission? There are two separate questions that get mixed up. Who owns the property and who inherits what in their estate? If the home is owned as joint tenants, the surviving owner typically becomes a sole owner automatically, which is outside the estate. If the home is owned as tenants in common, the deceased person's share usually falls into the estate, and then the no will rules decide where that share goes. If the home is in one name only, the surviving partner may have no right to the property at all. This is why dying without a will catches even organised families too. When you're dealing with this, someone has to be recognised as the person administering the estate, because banks, insurers, and the land registry won't deal with good intentions. That person applies for legal authority to collect assets, pay debts, and transfer what's left to the people entitled. If you're married, you're not automatically first in line to do that job, and you might not be entitled to the biggest asset, which is often the home. What people expect is, I live here, so I decide. What law does is show me the title and the authority. One situation I see a lot is where the mortgage has been paid from a joint account, but the property is in one name, and the surviving partner discovers that only blood relatives inherit. There's also a practical kind of knock-on effect that has nothing to do with romance and everything to do with admin. If the home or a share of it is due to someone else, the surviving partner can be pushed into discussions about selling, buying out a share, or moving at the worst possible time. Even where everyone wants to be kind, they may be dealing with their own grief, their own finances, and their own advice. It depends on the family, the paperwork, and the property setup. To cut the risk, focus on two clusters: people and roles, and assets and documents. First, people and roles. The trigger is any point where you've shared responsibilities, like moving in together or having a child. The action is to name an estate to lead in a properly prepared will. So there's no doubt about who can deal with the estate, so that's the executor, and speak to the various institutions. The common mistake is choosing someone because they're nearby without checking they can cope with paperwork and family pressure. A good checkpoint is that the person you chose knows they've been chosen, and you can picture them calmly handling calls and forms. So, quick question: if your partner couldn't access money for a few weeks, who would keep the household running without borrowing or begging? Second, assets and documents. The trigger here is buying a home, remortgaging, or putting one person on and one person off the title deeds. The action is to check how the property is owned, and if needed, get advice on whether the ownership should be joint tenants, tenants in common, or whether you need a declaration of trust to match what you both intend. If you don't know who the owners are of the property or how it's owned, typically it's generally owned as joint tenants, but make sure you check the title of the property. You can do this online through the land registry for about £7. The common mistake is assuming the mortgage statement tells you who owns the home. It doesn't always. And another mistake is thinking a quick online form is enough when the wider estate document and the property ownership are pulling in different directions. A good checkpoint is that you can answer without guessing whose names are on the title and what happens to each share if one of you dies. Because this isn't just about paperwork, it's about what people are allowed to do when things go wrong. That's why checking the title now can save a lot of pain later. Love may explain your choices in life, but paperwork is what other people are allowed to follow. If this has made you uneasy, it's probably your instincts, noticing a gap that can be closed. The reason this matters is small checks now mean less stress and clearer decisions when it counts the most. Tonight, take out the title information for your property and read the ownership section slowly, word for word.